Alrighty. How's everyone today? Good? Good. Well, welcome to the Rights-Based Environmental Protection panel. I think it's the last panel of the day, of the conference. This is probably going to be a very exciting, informative information for anyone who is looking forward to hope in execution. This is an important thing to get up to speed on. But let me introduce myself. I'm going to very generally introduce what this panel is going to look like, and then we're going to try to save as much time as possible at the end for Q&A to make sure that everyone here gets all of their questions, concerns aired out as much as possible. Okay? So, quick thing about myself. I'm originally from Florida. I had, your name is? They don't need to know my name. Sorry. Melissa Martin. I go by Mel. I'm with OSERA, which is the Oregon Citizens for an Environmental Rights Amendment. Other panelists will include Julia Olson from Our Children's Trust. I'm sure none of you know her, know of her, but we're looking forward to hearing all the stories from our panelists today as well. After Julia, you'll hear from Maya Van Rossum, who's the Delaware Riverkeeper and also founded and led the Green Amendments for the Generations, which is a national movement for green amendments, which we'll talk about very soon. And then Richard Grosso, who is a public interest environmental law practitioner in Florida, who is one of the very few, if not the only, attorney to have litigated a local charter amendment, right to clean water. And he has a lot of other. You have a very expansive perspective and experience to share as well. And then finally, we'll hear from Linda Perrine, who founded and created and led OSERA. And after that, we'll open it up to questions. So go ahead and dive in.
All right. Hi, everyone. I'm Julia Olson, and maybe I'll stand so you all can see me a little bit better. So I founded Our Children's Trust, and I did so because of these little guys. These are my sons. They're now 20 and 17. But when I had kids, I was like, oh my gosh, this public interest environmental law work I'm doing is not enough. We need something bigger. We need something rights-based. And really because their future and their right to life and liberty is a constitutional right, and we needed to protect it. And one of the foundational principles of Our Children's Trust work is that the climate crisis is the single biggest driver of health for every child born today. And so really the work I see that we are doing is fundamentally children's rights work. And in 2010, when I founded Our Children's Trust, we really founded the children's rights-based climate movement that you see globally now. So there was not a single constitutional rights-based climate case in the country or in the world, and so we've led that movement. And now I think there are over 60 children's fundamental rights cases filed around the world against government, and we have litigated about half of those, and we support many of the others. And three main things, and you've probably seen this slide if you've been to some of our other panels, but science is fundamental to defining rights. I'll talk a little bit about that. We trust children. We think they know what kind of world they want to live in, and so if we listen deeply to children, we will find the answers to many of our problems. And we still trust democracy, and I know there's a lot of people sort of giving up faith in that, and that is the opposite of what we need to be doing right now. We need to really double down on our faith in democracy and hold on to it. There's no other better system of government around the world available to us to really secure rights. And I think the courts are essential to democracy. And so we'll talk a bit about that. So Maya's going to really talk a little bit more about the history of what she has coined the Green Amendments movement. So I'm going to try not to duplicate, but I'll talk about some of our cases really briefly that have used environmental rights amendments or public trust rights and constitutions. The first one is Held versus State of Montana. We went to trial last summer. It was incredible. And we won 2 months later in August, a historic ruling saying that these young people have a right to a climate system and an environment that sustains and protects their lives. And I just wanted you to hear from them directly. So this case is a state constitutional case, and it's now up in the Supreme Court. We're briefing. We expect oral argument this summer. And Montana does have the right to a clean and healthful environment, but they also have other constitutional rights to individual dignity, equal protection, right to safety, liberty, life, property. And really importantly, Montana's, I think, the only constitution in the country that expressly protects the rights of people under the age of 18. And they did that in their constitutional amendment in 1972. So this is Maynard Ellingson signing the Constitution at the convention. She helped co-craft at the age of, I think she was 24, 25, the provisions that protect people's right to a clean and healthful environment and public trust rights in the state of Montana as part of the youth delegation there. And, I think you saw in the video, like smoke, the plaintiffs in this case call part of summer the smoke season now, because it's the best part of summer has been really taken from them. So this gets to the science piece. A fundamental question that we need to always remember when we're talking about rights-based approach to environmental protection or climate protection is the science. It informs that, right? And so the question that courts are going to be asked is, what is the safe zone and when does breach occur? So we bring experts into our cases to answer this question. And one thing I'll say about constitutional amendments, like Montana's constitution has had these great provisions since 1972, and yet Montana has approved every single fossil fuel permit it's ever been asked to approve. It has the biggest resources of fossil fuels in the ground. And so they were heading in completely the opposite direction. So without enforcement, constitutional rights are meaningless. So it's why the courts are so important. So Dr. Steve Rennie, he's one of the world's great climate scientists. He's just done incredible things. And he's retired, and all of our experts work pro bono. His testimony was really core to answering that question of where's the safe zone. And what every scientist, if you ask any climate scientist on the planet, they will not say that 1.5 degrees Celsius is safe. They will say we have to return atmospheric CO2 to below 350 parts per million. We're above 420 right now. So just to emphasize that. And fortunately, the judge, one of her findings of fact in the opinion where we won this constitutional case was to identify that number of 350 parts per million as the safe upper limit. And so we proved that Montana is violating the plaintiff's constitutional rights and is unconstitutionally depleting the natural resources of the state. And what's really important is the court found that current levels of atmospheric CO2 we're already in breach, okay? So that's the foundation, and every additional ton of greenhouse gas emissions exacerbates constitutional injuries and exacerbates breach. All right, so that was a very, very quick rundown of the Montana case, and we can talk more about that later. Checking my time.
You're good.
I want to mention Navahine. So this case is also a constitutional case that will go to trial this summer on June 24th. It will be the second ever children's constitutional climate trial. And Hawaii, like Montana, they had in 1978, we just came from a panel, so if you heard this already, I apologize. So there was the 1978, what they call the CONCON, the Constitutional Convention, and they amended the Constitution then to include public trust rights, environmental rights, and Native Hawaiian rights. So in this case, we've argued that defendants, basically the establishment and the maintenance of the transportation system in Hawaii is violating those public trust rights and the two provisions that the Hawaii Constitution has are the states required to conserve and protect Hawaii's natural beauty and all natural resources, and the citizens of Hawaii have a right to a clean and healthful environment. The Hawaii Supreme Court has already declared in a prior case, not ours, that constitutional provision includes climate rights. So they adopted Judge Aiken's life-sustaining climate right as part of their environmental rights provision in the Constitution. And this is the case, the Helco case, and I just wanted to show you two really important parts of this case that are from a concurring opinion by Justice Wilson, where he wrote that climate change is a human rights issue that inordinately impacts young people and future generations and disproportionately impacts Native peoples. And Justice Wilson wrote about the 350 parts per million standard. So it's the first Supreme Court to really adopt that. It's a concurring opinion, but to recognize that the science informs how we protect these rights. All right, I want to talk about our federal case just for a minute, because this principle of environmental rights is important to talk about in terms of the amendments that exist in constitutions, but also just in our constitutions as they stand even without any amendments. So in the US Constitution, we have the 5th and 14th Amendments, right, that protect our rights to life, liberty, and property, and our rights of equal protection of the law. And one of the things we've argued in this case is that the public trust doctrine is an attribute of sovereignty. So it is like the paper on which constitutions are written. It is foundational to creating government. And the public trust doctrine comes from Roman law, from Emperor Justinian. It also comes from indigenous laws that precede, written Western notions of law. And it's the basic concept that our air, our water, our seas, the shores of our sea, and other natural resources have to be held in trust by government for the benefit of present and future generations. And so in the Juliana case, the US Constitution doesn't have an environmental right that's explicit, but it is a foundational implicit right, okay? And so when we talk about amending constitutions to express what is implicit, we have to remember that we aren't creating new rights, right? You all have these rights. It is part of being human. It is part of living on the planet. And so it's important that when we go out and we do campaigns for green amendments, that we're not arguing that we are creating a new right that we don't already have. We're just codifying a pre-existing right. So really important in terms of messaging. So I put this case up because the US Supreme Court has recognized, this is a public trust case, but recognized the obligation of government to the people to protect natural resources. And even going back further than that, we have an originalist Supreme Court right now, so a lot of the work we do is to look at history and what were our founders saying at the time that they were drafting the Fifth Amendment. And so this is a quote from the drafter of the Fifth Amendment, James Madison, right after he left the presidency. And the founders, the framers of the Constitution, they were farmers and they were weathermen. They tracked climate. They understood changes in climate. And so here we have a framer saying that the atmosphere is the breath of life, deprived of which we all perish. Okay, so we have a lot of original history that our natural resources are essential. And I'm going to skip that. So this is the first court in the world to say that the climate is a fundamental human right, is Judge Aiken from right here in the District of Oregon. And just, to put a finer point on this is Levi. He was 8 when we filed the Juliana case. He's now 16. He's been displaced from his Barrier Reef Island off of Florida because of climate impacts from the flooding and the storm events. He now lives hours away from the beach that was his whole life as he was growing up. So, he has a fundamental constitutional right under the U.S. Constitution, and it's being severely impacted. I think. I'll just leave you with this, that again, when we're talking about environmental rights and constitutional amendments, we need to be ready to enforce them. And here's the danger that I want to flag for everyone. And we're seeing this in the way our Montana case is being defended by the state, by a whole bunch of Republican-led attorney generals who've weighed in as amicus curiae, and the U.S. Chamber of Commerce. So does everyone know NEPA? Okay. So our National Environmental Policy Act is thought of as a procedural statute. It's all about process, disclose impacts, right? But when it was drafted, it was not intended to be procedural. It was intended to be substantive and to be enforced against government. And the reason it's become more and more procedural is the way we as lawyers have interpreted it and litigated it and allowed the courts to sort of minimize it. And that will happen and has happened with environmental rights amendments and constitutions. So it's very important as a legal community and as litigators that we are not sort of unintentionally allowing these laws to become weakened procedural mechanisms. They are substantive rights, and how we present cases to the court and how we argue them and how we enforce them as citizens and demand action from our governments really matters. So I just want to flag that as one cautionary tale. And then I'm going to put this up for 1 second. We need help with our Juliana case right now, so if you want to get involved, you can go to that website.
Thank you so much.
You talked about the Constitution having rights, and we're not making new rights. I'm wondering if you guys have delved into the Ninth Amendment, unenumerated rights that we retain as citizens of the country.
Yeah, so we put the Ninth Amendment as a claim in our Juliana case in the beginning. It's been dismissed. I mean, the Supreme Court has made a mess of the Ninth Amendment, so it's hard to really bring a cause of action directly under the Ninth Amendment. And I think, part of the work we're trying to do is reclaim rights that have been diminished through constitutional interpretation. And look, the way that happens is folks on the far right bring case after case after case after case, and they are strategic. Like, I think, everyone now knows what happened with Roe, with Dobbs. That was a 50-year sustained campaign by the right? And we don't do that as a progressive community. And so, because sometimes we're afraid of losing, but they lost so many cases along the way in order to get to the win. So there's one thing to hold on to, like losses are part of the process of establishing and reclaiming rights. And we need to get better at doing that as a more progressive community, or we will lose the battle to the right who are doing it so successfully. So.
Do you have a petition for the Juliana case that we can?
Yes. So it's a Save Juliana campaign. If you go to our website, you can write a letter to Biden and the Attorney General and really help us right now with that case.
We in Washington State, our State Environmental Policy Act has language in the policy statement that each person has a fundamental right to a healthful environment, the exact language that you will see in a constitution, but it's in a statute.
We've litigated in Washington and we've lost multiple times, but we had a really powerful dissent by your Supreme Court, and so we're working on another round of litigation there. Yeah.
That's exactly what I wanted to hear. Thank you.
Okay. All right, Maya, are you ready?
Good morning, everybody. I'm really pleased to be here, and I do just want to begin by thanking Julia for bringing that beautiful video into the space and the voice of the children, whose voices she has so powerfully lifted up. That was really a beautiful way to start this. And I will say it was a real joy. I made a point of attending the 2-week trial in Montana when it was taking place, and it was really powerful, and Julia and her team just did such an effective job at really lifting up the power and importance of the constitutional entitlement in Montana's Constitution, but also just the right of all children to a clean, safe, and healthy environment and all people. So I just wanted to say that and express that it really was beautiful to be in the room for those 2 weeks. So as Mel said, my name's Maya Barmasa. I'm the founder of the National Green Amendments for the Generations movement and organization. I've written a couple of books on the topic, which sort of helped me found the movement. But I think the most important thing to me, really that I want you to know about me, is that I've had the honor for the last 30 years of serving as the Delaware Riverkeeper and leader of a 4-state advocacy and litigation organization focused on protecting the Delaware River and its entire watershed. And it's as a result of that 30 years of advocacy and activism and legal action that I've really come to experience, like so many of you, the myriad of ways that our current system of environmental protection laws fundamentally fails us, and to recognize that we do need a new pathway forward. I think we all know, but just to give voice to it, is in our nation, we have a wealth of laws and regulations and policies and programs and agencies that are all supposed to be focused on protecting our environment. And yet we still have communities across our nation that are experiencing devastating harm to their lives, to their bodies, to every aspect of their lives and their communities. And so we can see just by what's happening on the ground, whether we're talking about water, air, soils, climate, ecosystems, that we really do need new pathways forward for environmental protection. Or, as Julia said, to solidify and strengthen the pathways that already are in existence, but have been allowed to be degraded over time. So my contribution to this concept of alternative pathways to lift up environmental protection is what I call the Green Amendment movement. A Green Amendment is an amendment that gets added to the Bill of Rights of a state constitution and gives explicit constitutional protection to environmental rights. Now, every Green Amendment is an environmental rights amendment, but not every environmental rights amendment meets the definition of a Green Amendment. And I just wanted to sort of emphasize that, because the truth is there are lots and lots of states, frankly almost every state actually talks about the environment in their constitutions. Many of them talk about environmental rights. But at this point, there are only the 3 states, Pennsylvania, Montana, and New York, that meet the Green Amendment definition that I'm going to talk about today, which brings incredible legal qualities to environmental rights and environmental protection that are incredibly helpful as we are advancing this constitutional entitlement and this human right of people to a clean, safe, and healthy environment. So let me just share with you why I think Green Amendments are so important and why they are so strong. And I'm going to share with you what I call my fracking story. So as the Delaware Riverkeeper, I and my organization, the Delaware Riverkeeper Network, have been fighting for many years against the proliferation of fracking that was threatening the Delaware River and that was advancing in one of our watershed states, the Commonwealth of Pennsylvania. And given the state of the law at the state level, at the federal level, even at the local level when it came to fracking, fracking was really allowed to proliferate with tremendous ease in the Commonwealth of Pennsylvania. They pretty much were having their way, the frackers, with our environments and with our communities. But as I, experienced it and really talked about it, the frackers for themselves felt that it wasn't easy enough for them to advance their devastating operation and harmful impacts on our communities and environment. They wanted to find a way to make it even easier for themselves, if you can imagine that. And so leaders from the fracking industry actually in 2012 literally went behind closed doors and wrote for themselves a piece of legislation that was passed by the Pennsylvania legislature in 2012, signed by the governor, and when it was passed was dubbed Act 13. Now, Act 13 did a lot of bad things when it came to fracking, but just by way of example of the kinds of things that Act 13 did. Act 13 put in place automatic waivers from even the minimal environmental protection standards that would apply to every other industry, but now by virtue of this law would no longer apply to the fracking industry. Act 13 13 alleviated the fracking industry from the obligation to notify those on private drinking water wells that their drinking water had become potentially contaminated by nearby fracking operations. By virtue of Act 13, local authority, even a minimal local authority that could be put in place to try to protect communities from the proliferation of this industry, were preempted, were undermined, and by virtue of Act 13, every community in the Commonwealth of Pennsylvania had to allow fracking operations to come in and be located as close as 300 feet from people's homes. So right in the heart of residential communities, fracking was now going to be allowed to advance next to homes, next to hospitals, next to schools, next to playgrounds. And so, with the passage of this law, things were already bad in the Commonwealth of Pennsylvania when it came to fracking, and we still have problems in Pennsylvania when it comes to fracking. But with the passage and the implementation of Act 13, things were going to get exponentially worse for the people of Pennsylvania if this law was allowed to go into place. So I and my organization, the Delaware Riverkeeper Network, as one of the few organizations in the state that litigates, knew that we had to challenge this law legally. And there were actually 7 municipalities that joined us in wanting to challenge Act 13 because of the preemption of their local authority. Now, at the Delaware Riverkeeper Network, we were thinking what are going to be the legal arguments that we bring forward. And we recognize that actually in the Pennsylvania Constitution, passed decades before, in 1971, there was in the Declaration of Rights section of the Constitution an amendment that recognized and protected the rights of all the people of the Commonwealth to clean air, pure water, and a healthy environment, and the duty on all government officials in the state to protect the state's natural resources for present and future generations. Now the thing is, this language was added to the state constitution in 1971, so it had been there for 4 decades. But it hadn't actually changed anything when it came to environmental rights or environmental protection in the state, not in a meaningful way, because almost as soon as it was passed, it was robbed of its legal strength by the Pennsylvania courts, notably by the Pennsylvania Supreme Court. As the Chief Justice at the time said, the provisions of Article 1, Section 27 were emasculated, disemboweled, espoused to be just good public policy, right? Essentially good advice that could be ignored by the government officials of the Commonwealth of Pennsylvania. And so for 42 years, we had this really powerful language in the Pennsylvania Constitution, but nothing changed for the people of Pennsylvania or environmental protection as a result. Well, when Act 13 was passed, we at the Delaware Riverkeeper Network, I and my team, felt that Act 13 was such an egregious overreach by the industry and their friends in the legislature that maybe we were in a moment in time that we could actually persuade the Pennsylvania Supreme Court to reconsider that 42 years of bad precedent. And the long and the short of it is, in December of 2013, we did exactly that. There was a very conservative Supreme Court in place in the Commonwealth of Pennsylvania, led by a very conservative Chief Justice. And despite that, based on the power of the language of Article 1, Section 27 of the Pennsylvania Constitution, along with its Declaration of Rights placement, we secured this powerful opinion, with the plurality opinion actually written by the conservative Chief Justice Ronald Castile. In his December 2013 opinion, Chief Justice Castile wrote many beautiful things. It's a really, if you are an attorney or just somebody that just appreciates good writing when it comes to the environment, this opinion is really worth your time to read. But amongst the things that Chief Justice Castile wrote in this powerful opinion was he recognized that the drilling and fracking operations that we were talking about that would be allowed to advance as a result of Act 13 will produce a detrimental effect on the environment, on the people, their children, and future generations. That the natural resources that were being harmed were resources essential to life, to health, and to liberty, and that in fact the provisions of Act 13 that we were challenging did violate that long ignored environmental rights amendment of the Pennsylvania Constitution. And more than that, Chief Justice Castile made very, very clear in his opinion that the rights of the people of Pennsylvania to pure water and clean air and healthy environment were inherent, inalienable, indefeasible rights that belonged to the people of Pennsylvania by virtue of the fact that they were people here on this earth. These were not rights that were given by the Pennsylvania government. But because of Article 1, Section 27, these inalienable human rights were given highest constitutional legal recognition and protection in the Commonwealth of Pennsylvania. And so with that victory and the powerful words of Chief Justice Ronald Castile, we defeated some of the most devastating aspects of Act 13, preventing the proliferation of harm that would have happened. But at the same time, we breathed legal life into this long-ignored constitutional right of the people to a clean, safe, and healthy environment. Now, in 2014, very quickly, right, as good activists, we always pivot from a victory to what next? And so that's exactly what I and my team did. What next? And we thought about what made Pennsylvania's constitutional entitlement so powerful that we were able to overturn a law passed by the legislature and signed by the governor, despite having this very conservative Supreme Court. And we identified what were these elements. Well, amongst them, the language was in the Bill of Rights, the Declaration of Rights section of the Pennsylvania Constitution. That's where we protect the other human, civil, and political rights we hold dear. They get incredible legal and constitutional strength because of that placement. Well, Article 1, Section 27 placed environmental rights beside those other fundamental essential freedoms. It recognized that these were rights that belonged to all people, and it focused on the essential qualities of the environment that are so important to all of us. Things like water, air, right, natural and scenic values, and the environment overall. By virtue of the language of the amendment and its Declaration of Rights placement, the Article 1, Section 27 recognized that all government officials at all levels of government in the Commonwealth of Pennsylvania, not just the state legislature, but the local town council, the Attorney General's office, the governor's office, all the regulatory agencies in between, were all constitutionally bound to protect the environmental rights of the people and the natural resources of the state. And they had to protect the state's natural resources generationally. Right? Not just for those of us who are here today, but for the future generations yet to come. The amendment included this powerful recognition that the state is a trustee of the natural resources of the state, but that they are bound by that trustee obligation to protect those natural resources for the benefit of the people who are the beneficiaries, not their lobbyist friends, not industry and industry profits, but the people were the priority because of this recognition of the trustee obligation that the state had. The language was self-executing, so it was enforceable in its own right, even if you didn't have a specific piece of legislation to enforce its elements, and it was enforceable by the people when infringed upon, right? People could get access to the courts to vindicate their constitutional right if there was an infringement by government action and activities or inaction. So I dubbed these sort of the Green Amendment criteria after we did that analysis, and actually looked at every state constitution across the nation and found that at that time, in 2013, 2014, the only other state that recognized and lifted up environmental rights to the same highest constitutional standing in the same kind of way was the state of Montana. And really felt that we needed to change that. We needed this kind of constitutional protection in every state across the nation. But also as part of that work, all of this work, recognize that Pennsylvania's language and Montana's language weren't the be-all, end-all. There were other things we had to learn. So, recognizing that if there are other priorities with regards to environmental protection that are important to a state that we're trying to protect, it's good to specifically mention them. So specifically mention the right to a safe climate, the right to healthy soil. So we don't have to prove that they're part of our environmental rights, but our constitutional language says it. While Green Amendments give incredible power for environmental justice, let's not hope that a judge gets it right? Let's not hope that activists fighting for a Green Amendment understand it. Let's be very clear. Let's put a statement in our Green Amendment language that say that these environmental rights and the natural resources must be protected equitably for all people, regardless of race, ethnicity, tribal affiliation, wealth, gender, or geography. And if we have other values that we cherish, like the human health values, the cultural values, the recreational values of the environment, let's put it explicitly in the language. Now, I do want to touch on briefly, what is it that the other states do that have language, but it doesn't meet this Green Amendment definition? Some of this language is in the Bill of Rights section of the state constitutions, but it doesn't speak to those fundamental essentials like water, air, climate, environment. It speaks to things like the right to fish, hunt, and craft, or to navigate waterways, which is different, right? Or it may talk about environmental rights, but it doesn't do so in the Bill of Rights section of the Constitution. So there's a changed legal interpretation and entitlement there. And often that language specifically says these rights are just good public policy, or are to be defined by the state legislature. And so if the state legislature defines them in a way that has devastating consequences, well, the constitutional obligation and language was fulfilled, but perhaps the people aren't any better off. So those are just some of the differences that we see. I do want to acknowledge, like Julia touched on, there are other constitutional strategies that are at play, and these are not in tension in any way with Green Amendments, the passage of Green Amendments, or the Green Amendment movement. These different approaches, right, have incredible synergistic value. And when they come together, if we have two approaches happening in a state and both are successful, we actually just create stronger protections for the environment. Due to time, I'm not going to talk about Montana, but that's a great example. We have a Green Amendment effort advancing there that's going to be an incredible complement to the existing language and the work that Julia and her team and others are already doing in the state of Hawaii. The Green Amendment movement is a nationwide movement, but we're starting at the state level. We're going state by state first, and then ultimately we want to get a federal Green Amendment. We have secured a Green Amendment in the state of New York, so we now have those 3 states, Pennsylvania, Montana, and New York, passed in that order. But we also have Green Amendment proposals that have been put forth in about 15 other states, with more states coming on board all the time. Does it really make a difference? Yes. We give highest constitutional standing to environmental rights. We defeated Act 13. In the Held v. Montana case, Julia accomplished that amazing victory when it came to climate rights. But there are also a whole host of other decisions in Pennsylvania, in Montana, and New York that were able to be achieved because of the powerful Green Amendment language we now find in these 3 state constitutions. But it's not just about the law. With Green Amendments, we are also empowering activists and activism because they are now fighting for their people, for their earth, but they're also fighting for a constitutional right. And every time they get up to advocate for the environment, first words out of their mouth, I have a right. So there's a changed sense of entitlement that is really powerful for activists and activism. And there's also a changed dynamic when it comes to the decision makers that they're talking to. Because now when they're speaking to these decision makers, it may no longer be a difference of political opinion when it comes to the environment, but it is now that there is in place a constitutional obligation of these government officials to honor and respect the environmental rights of the people. And when they infringe, the people do have the ability to gain access to the courts. So government officials are starting to listen more attentively, and we're starting to get better decisions before we even have to litigate. So with that, if you want to learn more about the movement, forthegenerations.org is the main website, but from that website you can get access to any of the states where we've got major Green Amendment actions that are moving forward as per that other map. And of course there's also the vote. So thank you very, very much. I know it was a lot, but I'm looking forward to hearing Rich, and I appreciated hearing what you had to say, Julia. I think it's all a great compliment for one another.
Thank you so very much, Molly. So I think we're going to roll into the presentation by Richard Grosso. Richard, please take the floor, and don't forget to introduce yourself.
Hi, did I take the floor with my screen share? Does that work?
You took it.
Hi, everyone. really good to be here. Sorry I couldn't be there in person. I've been doing public interest environmental litigation and advocacy in Florida since 1986. Essentially worked for the state for 5 years, and then in '92 started my work on behalf of the environment on various nonprofit groups. Currently, I run a solo, private, public interest law practice. So I've been involved in trying to enforce a lot of and use a lot of the state of Florida constitutional provisions. Worked with Mel recently on a local thing here in the city of Titusville, and I've done a lot of work, both in court and at the legislative and policy levels around the state of Florida, local governments, state governments, and I've got a sense of what are some of the difficulties or challenges and the realities that we all really need to think through when we are starting a campaign for getting the Green Amendment approved and thinking all the way through to the end result and how we're going to enforce it. I do not have the breadth of knowledge of what's happened around the country that Julia and Maya have.
I'm so sorry, Richard. I didn't mean to interrupt you. Could you, just to expand your slides, are you able to go to your slideshow and I believe it might be a start presentation or something along those lines?
Yes.
Oh. Sorry about this.
It's at the top.
Does that work?
No, if you go to the top banner, it should have slideshow right in the middle.
Go over the menu at the top.
Yeah, menu at the top. Where, yeah.
It's just, Richard, it's just in your PowerPoint, right above where it says key considerations. There's a white button that says slideshow.
Are you able to see that?
In the menu.
Right above insert.
Oh,
There.
yeah.
Going.
Left.
Left.
One for the third.
Well, oh,
That's it right there. Click.
why is it a...
No.
No? The answer is no. Is there, can you at least X out your format background on your right? Yes. That'll help to expand it just a bit. I don't know why you're a pencil right now. I'm so sorry, Richard. Are we all okay as is? Okay, move forward. Disregard. My apologies. Okay. To you.
You can't see my screen?
Oh, it's just a little small. That's all.
All right. So the key considerations for me are, based on my knowledge of Florida, I don't have the breadth of knowledge around the country, but it's what you do is heavily dependent on your state constitution. Every state has a different constitution. There's obviously a lot of similarity, but what are your state constitution's limits on citizens' initiatives? They're draconian in Florida. Really, really difficult. What is the state governance structure? How much authority in the Constitution does a local government have versus that which is preempted to state governments? What are the requirements, both procedurally and substantively, for getting constitutional amendments enacted? Those are all of the key provisions that are going to determine what your strategy is going to be. So I can't figure out how to get this PowerPoint to work, so I'm just going to work off of, maybe I'm just going to shut it down now. Stop the share, and I'm just going to talk. So the first thing would be, what's the ease or difficulty of citizens' ability to amend the Constitution? There are things like, how many signatures do you need, over what period of time? There are going to be limitations on subjects. Certain subjects you can't do a citizens' initiative. In Florida, one of the things that we have to deal with is a citizens' initiative can only address a single subject. And if the Florida Supreme Court doesn't like an amendment, it can easily come up with reasoning that says that proposed amendment is addressing two subjects, not just one, therefore it's infirm, it cannot get to the ballot. There are summary, and title, and specificity requirements that you're going to have to be clear to understand in your constitution. So those are obviously key things you have to understand before you go about the task of trying to draft up a green amendment. One of the considerations is, are you trying to amend your state constitution or your local charter? Is that any better?
Almost.
So,
Yes.
Constitution, obviously, the benefits are it's going to be more expansive in terms of its impact. Of course, then it's going to be a lot more expensive to amend a state constitution. You're going to get a lot greater opposition from all of the statewide industries. It's trickier to write state level amendments because you're trying to deal with a much more generalized approach, a kind of one-size-fits-all approach for the entire state. If instead you want to focus on local initiatives, then they're a lot easier to pull off. They're a lot less expensive, a lot more doable to pull off. They can be much more tailored to specific geographic areas, specific locations, specific issues. But of course, local charter amendments might be preempted by state law. That's an issue that Mel and I are now dealing with. So it's a trade-off. You can impact the local charter, the local law, your city or your county much easier, much sooner, but of course it's not going to have the same broad effect of impacting an entire state constitution. Okay, are you seeing this? Are you seeing my screen?
Yes, we're good. Thank you.
So Mel and I have worked on a recent project together, City of Titusville, and so far we've been effective on, we've got a circuit court judge to approve, cases now on appeal, a local right to clean water in the City of Titusville. And I think some of the key aspects of that got us approved by the judge was that they had a very specific definition of what clean water would mean in the City of Titusville. We did not, unlike a different charter amendment, try to give rights to non-natural persons, to try to give rights to a lake, a river, waters of a certain jurisdiction. And the big issue in our case was whether state law preempted a local charter on our subject matter, which was water quality. The issue will be played out on appeal. There's a similar but not the same charter amendment for Orange County, which is Orlando area. Those folks lost. That charter amendment was found to be preempted by state law. So these cases are going to be traveling on appeal more or less along the same time frame. So they are, to be watched in the future. The on-the-ground enforcement thing is of paramount importance, I think. Particularly if you're doing something at the state level, you will have put an awful lot of time, money, blood, sweat, and tears, energy that could have gone into maybe other things into getting a state constitutional amendment approved. And so, from start to finish, you need to be thinking about, all right, great, if we get that done, and I'm now standing in front of a trial level judge, and I'm saying, I'm asking you to rule that this, whatever it is, this action, this inaction violates this, Your Honor, here's why you've got jurisdiction, here's why you've got the capacity to enforce this. We have a really strong separation of powers / political question doctrine in Florida that has been an issue. And certainly there's parallels to a lot of the federal political question jurisprudence that we've seen in federal constitutional law here. The self-executing issue is how I phrase it. It's how we phrase it in Florida. That the issue is that the nature of our business, the nature of environmental protection is that we are typically dealing with soft science, laws that are ambiguous, that require professional judgment to apply and interpret adverse effect, healthy waters adequate protection, things like that. At least in Florida, we have a history of very strong judicial reluctance and resistance to make policy. We have a very strict separation of powers doctrine. And courts are going to say, if you come and you ask me to enforce a constitutional amendment in Florida that reeks of language that we see as very specialized, very technical, requiring expert agency interpretation, we are not going to enforce that as a judicial branch unless and until we've got legislative standards that we can wrap our teeth around. We have some wrap our teeth around is a horrible metaphor. We got a couple of Florida examples. Here's some language in the Florida Constitution that were pretty big victories when we got them put into the Constitution, and you can see the language here. One of the lessons of Section 7, Article 2, Section 7, adequate provision shall be made by law for the abatement of air and water pollution and the protection of natural resources. And that the drafting of that signaled this ain't self-executing. It required that adequate protection shall be made. And so it's very clear that it wasn't meant to be self-executing, that it relied on subsequent legislative action. And we haven't had a great history of the courts saying, okay, we find that law to be inadequate for the protection because that's a buzzword that requires professional judgment. How am I as a judge in a position to determine what's adequate or not when it comes to protection of natural resources? That's been an issue, a limiting issue for us. Here's the polluter pays provision, and now in the same section. Those who cause water pollution, we were mostly looking at the sugar farmers in the Everglades agricultural area, shall be primarily responsible for paying the costs of that abatement. And what the Florida Supreme Court has said is, I can't enforce that. I am not going to find the legislature's budget and tax bill this year violates this because it's just too complicated. It's too complicated for judges to look at the different mechanisms of taxation of landowners in South Florida and figure out that really complex thing about what math do we do? How do we come up with a formula for us as judges to determine who's primarily responsible for pollution in the Everglades, which is itself a pretty technically, scientifically laden determination, and then how do we as judges look at the myriad laws under which we tax people for protection of the Everglades and determine under the that balance sheet who is or is not primarily responsible. And this is the language that we travel under in Florida. This is our standard. Does the standard in the Constitution lay down a sufficient rule that judges can apply to enforce the provision? Are there too many policy determinations unanswered in the language that we've used in the Constitution so that we feel inappropriately like we are judges are making policy and not enforcing constitutional policy? Those are the problems that we deal with in Florida. And I can only assume that other states have similar judicial doctrines that you need to be really well aware of if you are drafting one of these provisions. So to me, my final observations and recommendations, when you start out, have really clear objectives. What are you trying to do? Am I trying to require the hardest thing, and the thing you're usually trying to do, because you're not doing this unless the current state of the law in your state is inadequate. So you're probably only trying to do one of these if you're unsatisfied and unhappy with what the legislature is doing. So you probably are trying to come up with new policies, new practices, new actions that aren't already happening, or you're trying to prohibit things that are happening, you don't want them happening anymore. Or are you, on the other hand, just trying to maybe enshrine existing policies? Like in Florida, for example, every legislative session in the past 20 years, existing statutory protections have been repealed or really weakened. And so, we'd be making some progress to put in the Constitution, no law regarding environmental protection shall be amended or repealed as it existed as of a certain date. That'd be progress in our state, probably not progress in a lot of other more progressive states. I understand your journey from start to finish. When you're drafting language, always put yourself in the position of a lawyer in front of a judge 3 years later. Yes, Your Honor, here's what this means. Here's the kind of injunction you can fashion based on this requirement. Some things are easier to deal with. Some things are easier for judges to get their hands around. Limiting filing fees, granting broad standing, providing for good attorney's fees for the plaintiff, prohibiting prevailing party attorney's fees on behalf of the defendants. We have a lot of that in Florida. You try to enforce an environmental law and you lose, no matter the strength of your case, automatic attorney's fees against you. So you don't even try. Prohibiting things like that in your Constitution can be very helpful. Prohibiting other procedural hurdles. That stuff obviously is not as sexy and broadly impactful as climate and biodiversity and other types of things, but in some cases, they're more likely to get enforced down the line. When you are going for new standards, try to make them have definitions, objective standards where they're possible, baseline references, etc. Prohibit or require specific practices, actions, and results. I already talked about prohibiting reductions, and Perrine talked about issue area specific approaches. The McIver River Protection Basin shall not be impacted by certain practices. That kind of thing. We have a good land acquisition thing in Florida. X amount of money shall be allocated to environmentally sensitive land acquisition per year. That's something tangible and objective you can get your hands on. We have a really good provision in Florida. Lands owned by the public shall not be disposed of unless the government makes a specific finding they're no longer required for environmental purposes or such. So the bottom line is the more specific, the more site specific, the more geographic specific you can get, the more likely you're going to get a down the line impact. And I understand there's a tension there between some of the broader goals we're trying to achieve, and I'm not at all suggesting that we not pursue those things. And given where we are with the climate crisis and the biodiversity crisis, we have no choice but to be trying to get those types of initiatives. But it requires a hell of a lot of thought and detailed analysis and agonizing drafting to get them in a way that's really going to give you the bang for the buck down the line. And I'll stop there.
Awesome. Thank you so much.
Thank you so much, Richard. And I think that a big takeaway from this is that every state is a little bit different, strikes different, has different jurisprudence to really shape the approach and how you are going to, specify your solution to the problem set for your state. So in Oregon, we're going to hear from Linda Perrine, who has led and established the Oregon Citizens for an Environmental Rights Amendment. And instead of my face, you're going to look at this. And I'm going to make it big. And then have this as your background.
Why don't you go to the last one first?
I'll do that first.
And I'll let you know.
Okay, great.
So, yeah, thank you, Mel. Mel and I worked together on this, by the way. So Mel is as involved as I am on trying to establish a constitutional right here in Oregon. But before we get to all that, I wanted to just hit a few highlights of my background and how I got to the point of becoming somebody who, I'm not a lawyer. What I am is an engineer, an educator, a organic farmer, and a climate activist. And I've done all those things in varying settings. But one of the foundational things that changed my life was working for NASA in Houston on the Space Shuttle program as a flight controller in the Mission Control Center for Space Shuttle missions. And I worked about 30 missions while I was there. And the irony looking back on that part of my life is that I was trained on the environmental systems and life support console. And while I did that job, we would, train for it. We'd work missions for it. The crew would be trained to understand the pressure control system, the supply and wastewater systems, the air revitalization systems, the galley and toilet, the environmental control include flash evaporator, which was a cooling system, the water loops in the cabin, all these systems that kept the crew alive in this little tiny space. And they were all redundant. And they all had flight rules that said, oh, if the pressure control system has this particular failure, you have 45 minutes to get back on the ground and call it end of the mission. And then over the crew sleep period, we'd look at these beautiful views of the earth. And the crew would get up in the morning and they'd look at the beautiful views of the earth. And then they'd make statements about, this is such an amazing planet we live on, we have to protect it. Then we bring them back to the ground and they train for the next mission. They forget all about that part of protecting the planet. So I knew at some point I had to stop doing engineering and go do environmental education. So I picked up and I moved to California. And I did a little bit more work in software engineering in Silicon Valley, but in the meantime I was already starting to do volunteer work in environmental ed. Then I eventually got a master's degree in it, and I moved to teaching outdoor school and taking kids out on the trail. We taught them the water cycle, the carbon cycle. We taught them carrying capacity. And one of the most interesting things we did there is we would run this predator-prey game that would show deer, all the deer running around in the middle of the field, and a couple of kids would be the wolves, and they'd go out there and they'd have to take out the deer by tagging them, and we would plot the data after every round. How many deer did we have? How many wolves do we have? And you'd run the game again. So the wolf population was doing this and the deer population was doing this. And eventually you'd show, if you ran the game long enough, that it would steady state out. Then we'd go back on Friday and we'd have a debrief of what worked that week in environmental education. And I'd raise my hand and say, why aren't we talking about human carrying capacity? So I went on to teach at the college level. I've taught things like ecological footprint. One of the subjects, if you're not familiar with that, is how much our personal footprints are individually at a community level, at a state level, at a country level. And if everyone, all 8 billion humans on the planet today, lived at the lifestyle that we enjoy in this country, we'd need 5 planet Earths. I also do teaching on Electrify Oregon as far as electrification. And one of those things that we try to impress on people is the U.S. is, if you look at the carbon profile, the U.S. is still 3 times the next worst violator on carbon emissions per person. We're still at around 12 metric tons per person in this country. China's down at the 4 metric tons. So we have a special responsibility in this country to change what we're doing. And that's what I go out and talk in all kinds of formats about. So I moved to Oregon. I ran an organic farm. I wanted some land stewardship time. I stood at the Saturday market right here in Eugene for, 10 years, and I talked to people about the cost of organic food. I talked to them about, the Coast Fork is looking really low this year. Oh, and by the way, my farm is starting to dry out over the span of 10 years that I've been there farming. And so it was this activism going on in the market booth as much as it was selling product. Anyway, so put all that aside and we get to the climate situation. And I did 3 years with 350 Eugene here doing everything from the presidential puppets that were up in Portland, and we did that little thing Jim knew over there was one of the puppets. I did Obama and Kennedy, and Joni over here was the grandma and the whole thing, and we gave the message that over the span of President Kennedy's time all the way up to Trump at the time, not a single administration did anything to slow down the amount of carbon emissions that we were generating and continuing to ramp up. So I have done it in the form of education. I have done it in the form of activism. I have done it and done it and done it. And it becomes obvious at some point that we aren't getting it done. And so we need to push this into a national conversation, but unfortunately we have a stubborn or difficult Supreme Court. And I do think that at the state level, if we can get enough states to do these constitutional amendments, whether they are required, and I tend to believe it's implicit in the right to life, liberty, and property, but if you can't get the Supreme Court to decide it that way, then I think we're stuck with this. What do we do with that situation? So a constitutional amendment is going to explicitly say these things. They need to be explicitly said. One of the things that I always try to bring into my talks from my NASA days is, rather than looking, we all like to go hike, we all like to love love on the beautiful places of this planet. What we do not do is think of them as our life support systems. So if you're going to go out and do your own work, whatever that may be in your future, I really try to encourage all of you to start speaking in that language. We need to protect our life support systems on this planet. Okay, so now you can bring slide. Okay, so then in part of my activism, I became a delegate to the Democratic Party of Oregon platform convention in August of last year. And all the different counties submit their ideas for the various topics: housing, homelessness, healthcare, science and tech, environment. All of the different topics are there. Each county submits their ideas for the next 2 years for the legislature to prioritize. One of them was this idea of doing an environmental rights amendment. And so we had that in there. It made it through the environmental round, it made it through the delegate-wide round, and made it through the final. There was 3 votes we took, and it made it into the top 20 priorities for the legislature for the next 2 years for the Democratic Party. To do that, it requires a campaign. It doesn't just happen. So one of the things we did in the fall of 23 is talk to Senator Jeff Golden, who actually, unbeknownst to me and many activists in this state, was already trying to push a constitutional amendment into the state legislature and do it as a legislative referral. He got it into his own committee. He got some feedback out of his own committee that says, where's the grassroots? Who's asking for this? And he had nobody to point to. So we're going to do it this time, and we're going to do it in partnership with our Children's Trust, and we are going to push an amendment that is going to pass all legal muster because they've already been to the Oregon Supreme Court and learned the issues that they had the last time they were there. So we need everybody's help. We are trying to put together a May 4th statewide organizing campaign kickoff. If you want to get involved, it's going to be in Salem. Get a snapshot of the QR code there. We're working on things like websites and all of that. We are all volunteer. This is the way it's done in Oregon. It's all volunteer work. So it happens at a pace that we can keep up with it at. But we'd love to have you all participate. We need the lawyers. We need the teachers. We need the politicians. We need everybody.
Well, thank you. Did any of the panelists have anything else they wanted to say before we get into Q&A?
I'll offer one comment that came up when, so Maya was talking about the New York constitutional amendment, and that we're starting to see litigation around that. And, I think what's happening in Hawaii right now with the defense that we're seeing and what we're seeing with the New York Attorney General is really an indication of what we're up against. So Attorney General James said recently with respect to a case that's going up on appeal interpreting this new amendment. She said courts must be careful to avoid granting relief that goes beyond any mandatory directives of existing statutes and regulations and intrude upon the policymaking and discretionary decisions that are reserved to the legislative and executive branches. So even this really progressive Attorney General in New York is already pushing to try to limit the scope and the application of this amendment and the way courts interpret it. And literally every Attorney General and every state defendant in every one of our cases, and including the federal progressive supposed administrations, they will all defend to retain the power of the political branches of government, the executive and the legislature. That is what the attorney generals and the Department of Justice, what they're all situated to do. And they forget that this concept of separation of powers is to better protect the liberty of the individual citizens who give our sovereign rights to our government to help protect us. And so it's going to be this ongoing battle. So I just want to frame that up, and again, the enforcement and the way we do it is so important.
Yes, thank you so much.
So Mel, can I just build on that? Because I think it's a really great observation. And the truth is, I talked a little bit about Pennsylvania's history. After Pennsylvania's amendment got legal life, despite this very beautiful and very explicit and detailed opinion from Chief Justice Castile, we still had Pennsylvania Department of Environmental Protection, the governor's office, and others in government really pushing back against the amendment, mischaracterizing, saying, no, it wasn't self-executing. No, Chief Justice Ronald Castile didn't really mean what he said, right? This was just a plurality opinion. Even after the amendment was affirmed by a majority of the Pennsylvania Supreme Court, our opinion from 2013 was very explicitly affirmed in 2017. We still experienced that pushback, and it took about 5 more years, and then slowly but surely we've started to see the Pennsylvania government officials. Doesn't mean they don't push back when we're using the amendment to challenge them, but we are starting to see them properly characterize the amendment, properly characterize it as being self-executing, for example, which is what the Attorney General James, amongst other things, is pushing against, despite the fact that the New York courts have been very explicit. The amendment is self-executing because of its Bill of Rights placement. And for me, as we read all of the varying decisions, the successful decisions as well as the unsuccessful ones, when it comes to the amendments in Pennsylvania, Montana, and New York, I think one of the biggest lessons is sort of just to reiterate something that I said in my slides. If we want the courts and the government officials to interpret the amendment as being self-executing, as covering the climate, as having explicit environmental justice obligations, etc., then it really behooves us to take the time to say it in the language. In New York, that amendment was the proposal was very early on in sort of the advancement of the movement, and the legislator who championed it just had it in his head, he wanted only a few words. And so he let a lot of the other explicit language recommendations sort of go away, thinking that less was more. And now I think what he and others are experiencing is while the New York Green Amendment is being strongly interpreted and applied, we are having to make the case for things like self-executing. So it's just sort of educational that it really, again, helps us. Sometimes less isn't more. Sometimes, and we don't want to overdo it with too much, but there is a balance. And if we want the amendment to be self-executing, if we want to cover these other qualities, then we really need to think about including them actually in the language. So we remove the opportunity for judges, the courts, and government officials to try to mischaracterize the amendment as being weaker than it actually should be or is.
Thank you very much, Maya. All right, so do we have a first question? Go ahead.
Well, hi, Mike Allen from Florence, Oregon. And I first of all, I want to thank you all for your excellent presentations. I already heard from Mel and from Linda at our Elders Climate Action Group. Our Zoom meeting drew more people than usual. Elders. What we're looking for, and I love the pitch of the grassroots getting behind this, is how we can interface with the young folks so we can work together on this. And I will continue to reach out to you guys and bring our attention to the cause. Side question.
Oh.
You talked about a second approach, citizens initiative. This was mostly talking about legislative initiative. Can you tell us how those two might intersect? And
Yes.
how we as grassroots can help the cause?
Yes, of course. So if you couldn't hear us too well, but the questions were, and if I remember, one was, are there best practices or strategies to interact with and engage the youth, especially with elders, Elder Action Network and
Right.
things like that.
Third efforts.
Yes. So I'll open that up real quick, and would you like to tackle that, or?
Yeah, I mean, I think young people in Oregon and in other states where there are citizen initiatives happening around the Green Amendments are going to be really excited to get active. And young people are going to be really excited to connect. And I think I love the idea of young people connecting with Third Act and other, elder organizations, because it's such a great way to tell the intergenerational justice story. So once...
What I would also add
Yeah.
is, and I didn't hit it on the slide that was up there, we debated doing a 2024 ballot initiative in January of this year. And we decided we just couldn't pull that together. So we're now going to still build a campaign that's going to address trying to do a legislative referral in 2025. Okay, so we're getting it out there. We're going to build a campaign. We're going to be lobbying legislators and all those things. But the thing about doing it that way is the legislature has the final say in the potential language, in whether they even move it through committees. And so if they fail to meet our standards, shall we say, then we're prepared to back it up in 2026 with an actual petition ballot initiative that we would have to go gather signatures
They wouldn't
for.
go in parallel, they'd be sequential?
We can start the signature gathering anytime, yes. In fact, the May 4th event in Salem will do that.
Yeah.
Yeah.
A little overlap.
We
So I
should be
thought about
optimistic,
that.
I guess.
Yes, definitely.
It's easier if you get it through the
But
legislature.
one way or the other is the
Okay,
message.
great.
So I think, Maya, you had a quick touch
Yeah.
point? Go ahead.
Yeah, so what we found in all the different states where we're working as a partner to advance the Green Amendments, whatever it is they're actually called in the state, if they meet the Green Amendment definition, I call it Green Amendment, but they're not all actually called that. As you heard, in Oregon, it's going to be the Environmental Rights Amendment, right, which is great. But there really is no cookie cutter approach for how to do this in a state and how to engage all the different voices. But one thing that is pretty consistent is there is always sort of a leadership team that comes together. And one of the things that we try to do at Green Amendments for the Generations is make sure that in that leadership team, we have youth voices. And we actually see particularly in New Jersey and Maine, our youth voices are way out front, doing a beautiful job at embracing the message and help spreading the message to their community, coming forth, testifying, lobbying, and doing other things. So to me, including youth is really about making sure that they are at the table and amongst the leadership team, helping to make the decisions about what happens, when it happens, and how it happens.
Great, thank you so much. All right, question in the back?
I'm going to post this video with the hashtag PIELC24.
Okay.
And if you're on Windows, you can press 3 buttons. I think it's Alt Windows R, and you can record clips out of any YouTube or any video, any content, and make little Instagram, TikTok, shorts.
All right, great. So if you didn't hear that, this is being recorded, and you can find it on what platform?
Hashtag PIELC24, and I'm put on my channel as YouTube Todd Boyle, TODDBOYLE.
Okay, it'll be on YouTube, and you can find it by hashtag PIELC24. And you're able to, you're giving permission for us to use clips and such, or?
Yes, the video is the property of the speakers.
Right.
And that's why we can do this even though it's not PIELC policy.
Thank you so much. All right, there was a question over, yes, please.
Yeah, 2 questions, and thank you so much. This is fascinating. And also, I'm a born and raised Pennsylvania, so
taking advantage over. But one question is, have you seen a response to this movement? Because I know I live in Washington State, and in the legislature this year there was a similar constitutional amendment to try to shrine trapping, hunting, fishing into our constitution. So I'm wondering if you're seeing that in other states, and I don't know if that's related to this. We're also just seeing like more push for conservation legislation in a lot of states, and then that's bringing out, is sometimes seen as antagonistic to hunters or fishers or people who participate in those recreational activities. Go ahead.
I mean, I think, so it depends. It's, right now, like in the New York amendment, they didn't have a funded opposition campaign in New York, which is really interesting. But folks have tried, for example, to get constitutional amendments or legislative, like petitions for legislation as well on the ballot in places like Nevada and other states where they're going after utilities and they're having more specific initiatives that really target industry. And there you're seeing tons of millions of dollars spent to defeat those initiatives. So I think when we're talking about these, for the time being, we're in a little bit of a sweet spot where if we keep them, I think, simpler, and we're not targeting industry specifically, we're not seeing as big of a spend to defeat them. But that could change as more and more start happening. But I think it's, it's still worth doing, but it costs a lot of money to support these if you get the spend on the other side. And polling, so we were looking at initiatives in 6 different states with some partners. And what the polling shows is that the right to clean water polls really well. Sort of legacy and intergenerational justice issues poll really well. But the minute you get money spent to oppose these efforts, it really makes it hard to win. So they poll like off the charts before you get the oppositional advertising going. So it is something to consider in states. You have to raise a lot of money if we're going to outspend the other side if they start participating in the way that they have the power to do. Yeah.
I have one other question, but I don't want to jump in.
Do you mind if Richard answers? Go ahead, Richard.
A quick follow-up point on that. It's such a challenge, this point that you really just made, because, for example, we had a land acquisition amendment in Florida years ago, and in order to quell some opposition, the definition of what land acquisition money could be spent on, stuff got added to it to keep certain interests from not opposing it. And then years later, when a constitutional challenge to Florida's budget got brought, that stuff came back to haunt the sponsors of the amendment. Oh, well, those things, you said they were allowed, and they were not very environmentally protective things. And so there's just such a challenge to find a line between not bringing about opposition that'll crush the thing, on the other hand, not going so far to do that you've made your amendment, meaningless. This ain't easy stuff.
Thank you. Yeah, and I think that goes to the point of early education. Widespread awareness is going to be a big help to buffer things for us. And when they hear these opposition narrative, they'll be like, but wait, I heard this before.
Right.
Something's up. So that's why this network, this coalition building, is the best bet we have against those type of very well-resourced attacks. So yes, I think that's a great question. Do you mind if we come back to you for a second? Okay.
I just started working with these folks, and I'm an organizer, so leave your email with Mel if you want to participate. And the May 4th meeting is designed to have groups be represented. So I think Elders in Action has decided to be part of the coalition. So, having just a couple of representatives from them to come to the event is great. But think about all the organizations you're in. We'd love to come and chat with your organization about being a coalition partner and participating in the May 4th event. So there's 2 different things. There's the sign up for organizations and and individuals, but again, more organizations, and then sign up just with the campaign itself so you stay in touch.
Thank you so much. And this is like very all just interrelated because the coalition aspect of sharing information, such as how do you deal with these industry talking points? That's one of the reasons why we're happy with that Maya's on board, because she's gone through many states and fought the good fight in many states with many different types of industries, throwing rocks at things. So that type of information share is going to be also very critical too. And do you want to go ahead, and then we'll go back to your part two. Yes, go ahead.
As you mentioned before, the rights that are opposing like environmental things for industries for whatever reason, they're well organized and well funded. And I'm seeing like between all of the work of the speakers here, a mix of local, state, and national organization. And I think I want to know how people that are maybe on the fringe of that, or like my state, Tennessee, I don't know, like I think I know what's going on in my state, but I saw that there's proposed legislation. I did not know about that proposed legislation of how we can have a similar response or a similar model, because it has proven to be very successful for them.
Yes, absolutely. And I know that Maya has a website that has a list of all of the states that are currently advancing green amendment type of either legislation or or initiative. So you can check to see, is Tennessee on there, Maya?
Yeah, actually Representative Justin Jones was the lead champion for the state of Tennessee both last year and this year. Last year, the Sunshine Movement was at the forefront of the effort. I think this year, because of what was happening with all of those other really important issues regarding gun rights and democracy happening in Tennessee, it sort of got sidelined. Representative Jones did re-up the Tennessee Green Amendment proposal, which was fantastic language, but I think because of those other attentions to other important issues, it didn't get the kind of movement building that it needed to advance this year. But it was really important that he continued to put it forth, because then somebody like you, who's from Tennessee, says, hey, there's something happening there, how do I get involved? And what I would encourage you to do is, I'm pretty accessible, so go to the website, send me an email, and I or a member of my team will get back in touch with you for maybe how you could help lead that powerful part of the movement that's needed right now in Tennessee.
Great question. Thank you so much
Thank
for
you.
the information. So I respect your time. We're after the right bracket of this panel. So if there's anything else, you know how to get in touch with us. So thank you so much.